Hi, I'm Richard Gearhart, founder of Gearhart Law, full service intellectual property law firm specializing in patents, trademarks, and copyrights. We are a patent firm that has a specialty in life sciences. And with me today is our distinguished life science patent attorney, Ben Schroeder. Welcome, Ben.
Thank you. It's good being here.
And so we're going to be talking about things that an inventor needs to know if they want to file a life sciences patent application. What is the first thing that an inventor needs to think about when they're filing a life sciences patent application?
Ordinarily, I think people that file life sciences patents are people that are generally tend to be pretty familiar with the art in which they're going to be filing the patent. But what we would actually recommend is that maybe you file or you commence a search, patentability search on what you want to patent.
Like you said, I mean, a lot of scientists are already familiar with the literature in their field, but it's also important to do a patent search. So, why is that?
Just because you're familiar with the art that is the references that might be in your field, you may not necessarily be familiar with the patent area. A lot of times, if you're a scientist, you may not recognize that you actually have access to patent databases where you can look and see whether or not your invention is known. You might know that your patent, what you want to patent, okay, maybe has been patented before, even though there might be no literature references on what your potential invention is.
So I think that's an important point. So you're not always looking at patentability, but you're also trying to consider freedom to operate
Mhm.
as well, right? And what is freedom to operate?
Actually, let's step back a little bit, okay? A lot of people kind of have a misconception about what a patent allows you to do. A patent does not allow you to go out and make your invention. What it does is it allows you to preclude others from making what your claimed invention is. That's an important distinction that you should keep in mind when you're actually trying to file a patent application. It doesn't necessarily give you the ability to practice your invention. What it does is it allows you to stop others from actually making what you've actually claimed.
Right. So it has a preclusive effect. And when you're doing a freedom to operate analysis, you want to make sure that somebody else doesn't have a patent that can block you.
Oftentimes, there's what's called a dominating patent out there. And this is a patent that tends to be pretty broad in nature the patent holder might be able to preclude you from actually practicing in the area on which they have claimed subject matter.
I think we've managed to highlight the importance of doing a thorough patent search, and it's especially important when you're dealing with life sciences types of technology because we all know how critical patents are in the life sciences. How do you determine a filing strategy?
I think one of the things you want to do is you want to identify the areas, the regions in the world where you might want to file a patent applications.
How do you do that?
Generally, as a United States patent attorney, believe that filing in the United States, you get the most bang for your buck. Okay, it tends to be relatively inexpensive. Okay, yet you have access to the biggest market in the world.
Right, and in the life sciences world, the US market is king, right? I mean, that's really where you get the most revenue, the
Mhm.
biggest market, and so filing in the United States is obviously really important. But what about other countries?
A lot of times you want to file in countries where you think that you might be selling your product. So there's many considerations that you have to keep in mind. Are you actually gonna be the one who's actually making the product, or are you gonna be, are you gonna be licensing this to another party to make the product? All these considerations that you should keep in mind. There are areas in the world where, filing patents is important. They tend to be the developed countries in the world where particularly in the life sciences area.
You would say maybe recommend filing in Europe, Canada, maybe in Japan, Korea, China. Those are some of the major countries in Latin America. Probably Brazil is a pretty common country. But it depends a lot on your budget, doesn't it? I mean, because as you add all of these countries, it gets more and more expensive. And so you want to make sure that the filing strategy makes commercial sense as well.
One of the things you can do is you can kind of defer costs, okay? by going through what's called the Patent Cooperation Treaty methodology, basically. So what you would do is you would file an application, a general application, and then 18 months thereafter, you would file in the individual countries. You would file what are called national stage applications, whereby you're able to procure patents in the other venues where you've determined it's important.
Yeah, and I would just point out that Gearhart Law has a wide international network of patent agents that we can rely on for our clients who frequently do file patents overseas. Another topic that I wanted to ask you about is ownership of the patent. So, if you work for an organization or an institution, who owns the patent?
Depending on your work relationship, who you get. If you're actually an employee of a company, okay, and you use the company's resources to make the patent, it's probably the company that owns the patent. Now, at the other extreme, if you're an independent contractor, there are instances where you might be the person who actually owns the patent. What typically I would do is I would ask a series of questions to an inventor to determine who actually owns the patent.
Right. And I think one of the things that you need to look at then is whether you have an employment agreement or if the institution you're working for has particular policies around intellectual property. And so, if you're seeking patent protection, I think it's important to make sure that you understand your rights and obligations to the employer, but you also may be able to commercialize independently. What can I do to make my intellectual property, my patents in particular, attractive to investors?
A lot of that is actually gonna involve marketing, and so you have to go out there and you have to basically find angel investors, okay, that are interested, and basically what you're gonna have to do is convince them what you're trying to patent is valuable to them. It helps, to know what are potential uses for your patent down the line. There are many things that you wanna consider, though, as to how to determine the value of the patent.
So, thank you very much, Ben. It's been a real pleasure speaking with you. And as I mentioned, Gearhart Law has a specialty in life science intellectual property protections. Please contact us with any questions that you might have. You can find us at gearhartlaw.com, and we look forward to hearing from you.